as you said, Ellen and I will be just going through a few town planning fundamentals. Hopefully this will be useful to you, and hopefully you can gain something of value from this session. There's not going to be a lot of kind of breakout spaces or awkward team building exercise, so don't worry, we're going to try and keep it straightforward, but there is going to be a Menti just at the start. So just to warn you, if you could get your phones ready, and it's more purely to do for us so that we can gather a bit of feedback and we can make sure that we set the tone for this presentation, and we can cover topics that you really want to discuss. Okay. So who are we? I'm Josh Dickinson, obviously. I have 10 years experience working in town planning across a range of public and private sector clients, working as a planning subject matter expert and a project manager. I would say that my area of expertise is mainly around strategic land, infrastructure delivery and regeneration. So dealing with large, complicated sites with big infrastructure requirements is what I largely cut my teeth on. But I've worked across a range of scale of clients, so can provide input generally. And overall, my role within the Delivery Associates Network is as the town planning subject matter expert. So just to give you a bit of feedback on what I've been involved in so far on the Delivery Associates Network, it has really ranged from advising on how to implement a planning consent to talking about a strategic regeneration framework and how you can set the tone for good planning project management. So it covers anything and everything that you may have questions on with regards to town planning. With that, I'll hand over to Ellen.
Thanks, Josh. So hi, Ellen Sanderson-Clark. Been with Deloitte for 10 years now and experience of just a little bit longer. I have had varied experience generally across the sort of north of England, but also nationally on retail town centre planning, city centre regeneration, and more recently development advisory, sort of advising cities on regeneration of their city centres, and looking at delivery plans for how to make that happen. I'm currently working full-time as a delivery associate as part of the Delivery Associates Network, and I'm also working as a planning SME, supporting some places, the places that I'm supporting as a delivery associate and giving them the sort of planning advice that Josh has covered. I'll hand back to Josh to do a little intro, and then I'm going to cover the sort of master planning strategy elements of the presentation today.
Thanks, Ellen. So what is town planning, and what is its purpose? The purpose of the planning system is to contribute to the achievement of sustainable development. And there are three dimensions to sustainable development. There's economic development, there's environmental, and then there's society. So it's about the meeting point of all of those things and achieving outcomes that will enhance and improve all three of those sectors. The town planning involves two key activities. These are plan making and then development management. And what we'll try to do is we will try to go through those processes with you so that you can have an overall view, and it will enable you to have conversations knowing the structures in which we operate. So what we will cover in this session, as we've set out there, is what is the plan making process? Where does legislation and policy sit next to each other? How do they structure themselves? And then focusing in on local plans and how do allocations and local planning authority policies come to be. We will then develop that slightly further. Ellen will tell you about the role of master planning, specifically in relation to how do we get together large-scale regeneration projects like the ones you're working on and how can create the planning structures for them to be delivered. We'll then move on to what is a planning application, because it forms the next step part of the planning process. What considerations and risks you should look out for when preparing a planning strategy before you submit a planning application. how a planning application moves through the system, and then what can happen after a planning application is determined, because one of the kind of mythbusters that we have to often deal with is that once you get planning permission, it's not necessarily the end of the planning, and that it obviously needs to be constantly managed and finessed through various different mechanisms. And then what we've got at the end is just a little bit of good practice advice from our colleagues and from industry experts that we've spoken to about how we can improve town planning and make it less of an issue for developers as they go through the process. So, as I said at the start, we do have one part of interaction before the questions and answers, and that is the Mentimeter that's set up. So this is really, it's just going to be 3 key questions that Ellen's going to run through, just so that we know what your kind of basic understanding is and what you would like to be covered in this session. So Ellen, can I hand over to you to set that all up and run that? That'd be great.
Yeah, sure. So if you've got your phone with you, you can scan the QR code and it will just take you straight to the quiz. If you haven't, if you go to menti.com and at the very top of the bar, if you just type in the code 42433433, then it will take you to the questions. So the first question we've got is how much experience do you have of planning? Just be really good to understand who we've got on the call, so that we can make sure that we're going into enough detail about the basics if need be, or focusing on the more detailed elements if everyone here sort of has a grounding in the basics. So we'll start with that. If we can, everyone can add their answers. Oh, hang on. I think I've messed this up. I think I need to log in again.
Just to say, I've submitted my answer and it's saying the presenter hasn't changed slides yet.
Yeah,
If that helps.
Right, I'm on it now. I was trying to do it on my phone and be clever, but I had to go on my laptop. Right, so what we've got 3 people asking what is planning, 3 people asking what understanding the principles, and 3 people saying they've got a good grounding. So a good old mix. Great, okay. How do I change the slide? Sorry, super professional here. Just trying it for the first time. There we go. Has everyone got the next question? So what is the one thing that you find most challenging when navigating the planning system? Able to put their responses in. So first response, the process. Haven't really used it yet. Don't navigate as part of my role. Heritage and conservation related issues. Consultation needing to do beforehand. Complexity and pre-planning issues. Yeah, a range again. What additional elements are required, such as conservation area consent and the complexity of it. So yeah, I think there's a bit of a theme here. Hopefully we can sort of demystify some of the process side of things today. And we've also got a handout that you can, and some flow charts that you can use to refer to. And yeah, we are going to go into some of the more detailed elements as well. I think things like conservation area, or the additional elements that are required outside of just straight full planning permission, hopefully we can cover some of that. But I think it's also worth noting that there will be some additional training sessions through in time about specific things like EIA, etc. Environmental impact assessment. I'll check myself for using planning jargon. So yeah, hopefully we can cover everything that we've got there today, or in due course.
Brilliant.
So we've got one more. What is the one thing that you would most like to demystify? Hopefully similar themes, but I think it's slightly different, where planning is often a very dense process where if you're not in it, you don't know, which is incredibly challenging. So we've got a question about master plans, how much weight can be applied. I can cover that. Just waiting for the rest to come in. The high cost of using consultants in providing all the surveys, timescales. Another timescales question. Best way to navigate, and timescales again. Best way to navigate the different aspects in a timely way so as not to hold up delivery timescales. Hopefully we can cover that in the sort of strategy and de-risking aspects.
Brilliant.
Back to Josh.
Ellen, do you want to, we'll hold on to those questions, and anything we don't feel we have covered, we can start at the end of the presentation to kind of maybe just providing some answers to that, which will be really helpful.
Yeah.
So we'll hold on to those. Brilliant. Okay. So we're going into what is the plan making process. So what you may hear if you've engaged with town planning before is that the UK town planning system is plan led. That means that planning decisions must be made in accordance with the provisions of the development plan unless material considerations indicate otherwise. The development plan is the policies contained within the planning system hierarchy, which I've set out on the left of the presentation. And the way that we navigate this is it often works top down. So, and I think another really neat way of remembering it is that we're kind of split into two areas. It overall is the legislation law. That's the Town and Country Planning Act, General Permitted Development Order. These are things that we must accord with. And when we discuss planning and we talk about planning matters, this is not something that we discuss. You're either in compliance or you're not in compliance with it. And an easy way to remember is that legislation is law, and that is the purview and the moneymaker for lawyers, not planners. Planners are much more interested in policies, shaping policies, applying policies, and understanding how we can balance the requirements of all of the policies across the development plan to create a sustainable development. So policies are led by the National Planning Policy Framework and planning practice guidance documents that are published by the government and the Department for Levelling Up Housing and Communities, or whatever it will be called in the next Parliament. At the next level, we move down in the scales of geography. County councils often produce plans related to minerals and waste plans, and often are in charge of local highway networks and key infrastructure delivery because they span wider geographies. At the next level, we have regional and combined authorities. So these are places like London or Greater Manchester, or you may see somewhere between a county and a municipality, where places like Gloucestershire, where they may create a specific plan that deals with strategic issues across the wider area. But I would say that the principal facet of the plan making system is a local plan, and that's contained at the local authority level. So a local plan is where policies specifically related to site allocations, technical policies on housing, the environment, heritage, and town centre development are located, and including greenbelt as well. And often the best way to develop plans and move forward outline principles is through the plan making process, through a site allocation, which we will go into a second. But then beneath local plans, what you have are neighbourhood plans, strategic regeneration frameworks, master plans and visions, which look to supplement the local plan and provide greater detail and clarity around development coming forward. So these documents shouldn't create new policy. They should supplement what is already in the local plan and provide greater certainty for people to discuss and consider when it comes to bringing forward plans. So what we're going to focus on here a little bit is more along the plan making process to produce a local plan, which is where those key policies that guide development and often cause a lot of issues are contained. And the process is linear, and it's designed around getting enough engagement from statutory consultees and local people so that they're clear on what policies are coming forward, though clear may be not the right term to use because it is quite a dense process. So what we start with is what we call a Regulation 18, which is an issues and options and a call for sites consultation. This is the start of the process, and this is where a local planning authority will effectively do all of their evidence gathering and set the baseline. So this will be all of the baseline reports that you can imagine. So strategic housing and employment land assessments, it's flood risk assessments, it's taking a view and testing the robustness of housing numbers, and then also testing things like the need for regeneration in town centres. And what this does is, what happens is all of the information is pulled together, and there is very little requirement for what needs to be produced from it, other than that you will go out to go out for consultation, saying that this is the evidence we have gathered. That is when you do the issue side. When you do the options side, it's about taking that information and going, okay, these are the options. These are the set of reasonable options that we see of bringing forward development in our area. After that consultation, it often moves on to what we call a draft local plan. This is a Regulation 19. So this is the first time that the public and statutory consultees will see policies that have been developed out. This is the statutory requirement is that this process must be for a 6-week period, and must contain the policies and allocations that look to be drafted and will be submitted. Once that stage is done, we move on to the submission of the local plan to the Secretary of State. This is where the local planning authority will send the plan to the department, and the department will appoint the planning inspectorate to undertake an examination in public. And this is where they will set up hearing sessions, and they will test the soundness of the policies, and the soundness policies are contained in the MPPF, and they guide effectively. They do not change the wording of the policy. They test more the process at which the council have got to that point, and whether it is a fair reflection, whether it is justified, whether it is consistent with national policy. Once that examination program in public takes place, it moves on. The inspector will find it sound, and then it will send it, or will send it back with proposed alterations, which the council can choose to take and implement so that it can be adopted. And then what happens is that local plan will then be the local plan for the next 15 years, subject to a review every 5 years. At the end of the process, there is a 6-week period for legal challenge that can be made by third parties, but a legal challenge can only challenge on the process that has been made. It can't, if it's not a case, if it's a planning judgment, that a legal challenge can be launched. Say if someone disagrees with a policy, it's whether the process of getting to that policy was unjustified and didn't follow the legislation which it should have. So as policies are developed, they gain weight as they move forward through the planning system. So if there's a policy and a draft local plan that a developer is looking to rely on, it's given limited weight because it hasn't gone through the steps of consultation through to adoption. Whereas if a planning application was being considered and the plan had been found sound and it was expected that the local authority were going to adopt it, it would be given more weight when making a decision. I can't see any hands, but I will assume that we'll save questions till the end, and I will hand over to Ellen for the next slide.
Thanks, Josh. So moving on to something a little bit more or less process driven. So between the local plan policies being adopted and submitting a planning application, it's often desirable to have some additional planning guidance or similar guidance that gives some more clarity on what's expected of a site or a place or an area to help drive change that's a little bit more flexible as such if it's not through the formal local plan process, but still carries a great amount of weight. I'm covering this in quite a lot of detail because I think a lot of the projects under the Levelling Up Fund and similar are sort of part of a wider long-term vision for improvement of places in the long term. So I think this is a really good method that planning can support the whole scale sort of regeneration of places that can also be flexible and respond to market changes over time. Why might you want to use a master plan or what other names have we got for it? A strategy, a vision, etc. I think it's that they're often developed through extensive consultation. They can be more dynamic than local plan policies. It can help achieve longer term objectives even than the local plan, and it gives clarity to investors and funders about what's expected from opportunity sites, and you can sort of incorporate a delivery plan in that. So it's sort of realistic and opportunistic, and it can really help define the future of a place in the way that within the restrictions of the local plan, it's quite difficult. So there's various mechanisms for preparing master plans as the overarching heading. That might include visions, strategies, supplementary planning documents, strategic regeneration frameworks, etc. It's often produced as supplementary planning guidance or under another name, a sort of endorsed document. And it's used to set a strategic trajectory for future development of an area. It would focus on a particular focus or growth area that might be identified in the local plan and give more detail about that. And it'd be used to seek to achieve priority outcomes, whether that be economic, social, environmental, etc. And it helps to give a sort of holistic balance across all those considerations. We had a question about weight of master plans in the planning process. So these documents or visions would form a material consideration in planning decision making. So when you're sort of in the planning balance, we call it, you have the policy on one side and then you have material considerations on the other side, and you can justify a departure from policy using a material consideration, or you can add additional weight to policy using material consideration. And that term covers basically anything that is a consideration in the planning decision making. It's undefined and a big old beast of basically anything. But this document as a sort of well consulted document would generally have a great amount of weight in that decision making. We also had a question beforehand about how to make these documents effective. And I think the fundamental of that is around the sort of consultation side of things. So they'd usually be prepared for consultation with the general public, with other stakeholders, and with formal support from the local planning authority or the local authority, through committee or cabinet endorsements, publication, etc. So there's a great amount of weight there that it's been a well consulted and considered document that's meeting the priorities of the stakeholders involved. It's just a bit more sort of thought on why you might choose this mechanism. So they can really help stakeholders understand the investment decisions being made, which can make the planning process, when you get to application stage, smoother. They can also be more dynamic, as I've mentioned before. They can allow changes over time to respond to economic conditions, changing political priorities, etc., without needing to go through the full formal local plan process. So they can be really useful in that regard. They can help achieve longer term objectives. They can be used to encourage market making, correct market failure. And I think it's often particularly used where places would otherwise be subject to sort of ad hoc, short-termist development that doesn't align with strategic objectives. So it really helps the local authority give direction to what sorts of development they want coming forward to help achieve a longer term objective, rather than just delivering something that the market needs in the short term, or that's viable. I think most importantly, these documents can give clarity to investors and funders, both the public and private sector, about what's expected from a particular opportunity. So it can inform sort of land values. It can be used to apply for funding to demonstrate that outcomes can be achieved. And then it, like I say, that's the sort of market making point where you might use it to catalyse wider regeneration in a place. Excuse me a second. I think central to developing such guidance is the consultation process, as I've said. Sorry. These processes are usually led by the local authority, but maybe done jointly with a development partner. It might be appropriate to sort of employ consultants to input with specialist expertise, urban designers or master planners, development and delivery advisors or other technical specialists, depending on the sort of site-specific requirements. Sorry, I'm just going to go on mute a minute. Thanks. So just while we're on the sort of subject of who inputs, I think it's a really good opportunity to sort of de-risk some of the planning process as well, if you get the technical specialists in early to sort of understand what the site constraints are or what the site opportunities are, that can then really inform what type of development and what form of development might come forward, so that when you get to the planning application stage, you've already done that and you're not wasting time sort of considering things that are going to prevent development coming forward. So that's a really good opportunity as well for, I guess, sites where it might be particularly windy or particularly contaminated, so that people have got a real in-depth understanding of what the site constraints are. So what might you include in such a master plan, regeneration framework, etc.? Excuse me again. They're usually front-loaded by a vision, which would set the sort of vision and strategic objectives for the area that all the stakeholders are bought into. Again, this would usually be informed by the public consultation process, and it would really clearly define the future of the place. And that really helps people buy in to the opportunities and potentially create some real excitement about that can carry the proposals through to delivery. Vision is usually used to bring together sort of stakeholder narratives around existing and emerging priorities, various programs or policies, not just within planning, but potentially other areas. I think it may be sort of highways, policies, etc., and aspirations, to make sure that everything's aligned, so they can be really useful for bringing together all the thinking about a place. And it also includes an opportunity to have a review mechanism, so maybe every 3 to 5 years, and that can be used to sort of demonstrate progress and update the vision to reflect market conditions. Would usually always include an existing analysis, and how that then relates into the drivers for change. So why does it need to be regenerated in a particular way? Why does a particular type of development need to come forward? And making sure that that's fully informed by the existing condition. So again, at this point, it's a sort of stakeholder input, and then again, you'd consider what technical work is required to support that. And then the crux of it, I guess, the actual master plan and the principles for how development would come forward, be expressed in a variety of ways. So a sort of traditional master plan, a spatial plan of the development, and visualizations that would inspire change. It might include advice on the types of land use that would be encouraged, target markets, etc. Most often than not, including placemaking and quality principles. Again, I think the point here comes in about weight and how these should be applied through the planning process. There is, obviously they're not a formal policy, but I think the fact that they've gone through the various considerations, you are able to give a great amount of weight to that through the planning process, so that it can be a really useful tool for avoiding undesirable development, and encouraging a particular type or scale or density or whatever of development, as well as thinking about things like supporting infrastructure, so whether there's schools or doctors' surgeries, public realm, car parking, etc., is needed to support the scale of development that might be coming forward. And I think we'd always recommend including a delivery plan, and that delivery mechanism is threaded through the whole master plan to enable a sort of achievable proposition. Because I think considering a bespoke delivery mechanism at the outset really helps ground these in realism, and then that can help give weight to the decision making around it. In a delivery plan, it's sort of specifically considering things like catalytic opportunities, so whether there's a particular site in a particular location that's, you know, a gateway, or it looks particularly awful and it's really putting people off, or maybe like a site where there's noisy or whatever uses, where you can move them, relocate them, and put something on there that will really inspire change and catalyze investment beyond that. The sequencing of proposals, again, what's appropriate to come forward first? Do you need infrastructure to then support later investments? And then considering sort of specific delivery mechanisms. So conditional land disposal, particularly for catalytic opportunities, whether you want to consider a joint venture or co-investment, strategic partnering or development corporations, and how you are actually going to bring forward these amazing aspirations. And then considering funding options at this point as well, just to really ground the principles in realism again, as well as considering whether any phasing is appropriate. So that might be used to then take forward a prospectus, whether you need any sort of initial public sector intervention or whether you need a development partner, etc. So considering that upfront, as well as, I guess, maybe then if you understand the site constraints of it being particularly contaminated or needing a highways intervention, you can sort of look for funding in that ways. And then also considering governance arrangements, seeking to ensure ownership and drive, and sort of thinking about that at the initial stage can really help move things forward, and gain traction if you've got someone sort of owning the delivery aspect of it. I covered quite a lot there. Hopefully that all sort of makes sense. I'm going to move back into the sort of technical planning world now, but if you've got any questions about this, we can pick them up at the end. So if we could have the next slide,
yes.
Josh.
Ellen, just before we move on, I think just from me, just as two kind of key takeaways for this group, I would suggest thinking is, firstly, we talk about master planning. I think a lot of people confuse a master plan with the plan that you get, which is a big kind of map view of what you want, in comparison to the most effective master plans are those which view a project as a major program and take in those kind of key considerations, and that actually the plan that you get at the end is merely one of the outcomes of effective master planning. And then I think the second point that I just wanted to raise was that, and I think it's a very key point, is that it depends who's driving the master plan will affect how you best use it and which tools you use to be able to implement it. So we've talked about the role that, say, a local planning authority wants to be the ones that drive it and get it adopted. Then you would use things like supplementary planning documents, etc., which are then endorsed by the local planning authority. Whereas if it's something that is being driven by the private sector or potentially urban designers and developers, then it's much more effective to have it included within the outline planning application, or at a later stage, which allows it to then be consulted on effectively as well. So I think just be very clear, firstly, what a master plan is when we're talking about it, and secondly, who is driving it and what is the best route for that part, for that team that are driving it, to get it adopted and in place.
Which is a very timely point for the next slide. So what is a planning application and what form is there? I'll sort of run through this fairly quickly, I think. But I think when you're sort of setting your planning strategy, it's really helpful to consider what types of application and what the process is for the decision making, so that you can help determine the risk appetite, and whether, such as wanting to front load the application and relying on amendments and conditions, or if you want absolute clarity on everything, just submitting everything up front and committing to the spend. So what is an application? A planning application is the submission of information to the local planning authority for agreement. It's used to demonstrate the impact, both positive and negative, and how the development is mitigating its impact. Compliance with planning policy is the easiest way to secure planning, but you can deviate from the local development plan and other policies if you've got material considerations that indicate otherwise. So planning permission is required for everything that falls under the definition of development, which is the carrying out of building, engineering, mining, or other operations in, over, or under land, and making any material change of use to the buildings or other land. I think that's right. Learned that at uni. Still in my head. There are some provisions for smaller scale or particular types of development where you don't need to apply for sort of full planning permission. We call those permitted development rights, and they are defined in law. For some of those, you do still need to submit an application to the council to confirm. It's called a prior approval application, but it's confirming that it is covered by the permitted development rights. And then you need to consider what type of application is appropriate. So we've got a list of 9 here, types of application. Full or outline are the ones you're probably familiar with. You can sort of also do a hybrid, which is part full and part outline, where you might want to, I guess, thinking about the master planning side of things and timescales, you might want to crack on with a particular phase, but not have the clarity on the later phases and define those once you've sort of made your market with that first catalytic phase. Then got specific things like advertisement consent, listed building consent, the specific ones that cover different types of development, I guess. Conservation area consent is no longer a sort of thing. You'd need to then apply for, if it's within a conservation area, it needs permission, you apply for sort of full planning permission in that regard. You can then amend a decision once you've had it, which just going to sort of run through later, so I'll leave that for now. You can then also apply for a certificate of lawful or proposed development or use. So that might be where you've implemented a planning permission and you want to confirm that it's been implemented and legally, and that you can build the rest out. Or it might be that you consider a particular change of use is lawful, and that you want confirmation of that you basically don't need to apply for planning permission. And then we've got the prior approval point that I've already covered. Also want to consider decision making in your planning strategy. There's 3 different types. Most applications be determined by a delegated decision, and that's under the council scheme of delegation. Load of sort of techie words here, so if I'm using jargon too much, then let us know at the end if you want us to define anything in particular. But effectively, there's an agreement in the local authority and the council that particular decisions can be made by officers and don't need to be made by the planning committee. So effectively, the planning committee is delegating those decisions to the officers, and they're usually minor applications, ones that haven't received much objection, or that are in compliance with the development plan. Planning committee, so the planning committee is a set of elected councillors who are the ultimate sort of decision makers within the council on planning applications. So they might, again, if it's in their scheme of delegation that they want to make decisions on certain applications, ones of a certain size, ones with a certain number of objections, or that don't accord with the development plan or any other sort of considerations, they might just sort of call in because it's politically sensitive or whatever else. And then you have Secretary of State call-in powers, which a very small number of applications might be called up for if they've got national significance or if they cross local authority boundaries, or again, incredibly politically sensitive. The Secretary of State might decide to make the decision himself rather than leaving it to the local authority. It's useful to consider what decision-making process that your applications will be subject to, because that can help inform the type of consultation that you might want to do, and how much you might want to involve sort of ward members. You might want people to speak in support of your application at committee, etc., to help support. So I think considering that early on is always really useful. What else was I going to cover here? So once it's submitted, the council will then consider if the application is valid, i.e. if it contains enough information to assess the application against policy, and then they make a decision on the application through a specified determination period. Again, we've got more detail on that later. I'll just move on because I think we're using a lot of time and I really want to cover the next slide. So again, sort of thinking about strategy setting, what should we be aware of when preparing a planning application? So this is setting a strategy up front, and really thinking about what the risks are to your planning process and seeking to mitigate them early on. One of the sort of formal mechanisms for that is using a pre-application service, which most local authorities offer at a fee. But it's a way of working through with planning officers and consultees what their considerations are and how your application will seek to mitigate that. I think it's something that is worth sort of doing up front, and then it can be refreshed as you go through the process. You might have a multi-stage pre-app depending on the scale and level of objection or comments on the application. If you've got an iterative design process. But yeah, as I say, engaging positively with this process is a really good way of de-risking the time and the cost of a planning application. It's also useful to use that process to agree the information that's going to accompany the planning application, so you're not doing too much or too little. And again, that'll streamline decision making as well later down the line, so it can help with programming. A planning performance agreement is a formal way of working with the local planning authority, which is probably less relevant to you all, but something to be aware of, I guess, if you're working on major projects that have multiple stakeholders in. It's effectively an agreement between the applicant and the local planning authority on the process for determining the application. So you might have a target submission date or a target determination date, timescales for responding to consultee comments, etc. that will then help define a programme and help achieve milestones. Again, that's usually subject to an additional fee. And then sort of wanted to talk about managing and mitigating planning risks. So there's various things that we would recommend thinking about upfront on what is going to impact your planning application and how to mitigate that as far as possible. It's quite a big exercise to prepare a full detailed planning strategy, but it's worthwhile in the long term. So considering things like risk appetite, what are the drivers behind the planning process? What do you need? What does the project need from it? For example, have you got a particular program? I'm thinking specifically on this with funding deadlines, etc. Do you want to get approval of as much information up front to de-risk that, or are you happy to wait and have details reserved by, have a reserve matters and an outline, or reserve details by conditions? It's worth considering how the development will accord with the development plan and what material considerations you'll need to employ to justify otherwise, and what technical information you'll need to support that. Considering if environmental impact assessments are needed, and doing screening and scoping exercises up front, which are effectively agreeing the scope of an environmental impact assessment if it's needed. This is a particularly sort of technical work stream, which we'll have another session on, so I'm not going to go into too much detail, but it's something to be aware of as a planning requirement. Stakeholder mapping is a really key part of setting a planning strategy, and again, we're going to have another session on that, so I won't go into too much detail today. But it's sort of mapping the stakeholders in terms of who they are, what issues are they going to be interested in, how will they be consulted, what information you need to give them to seek their support, and what will need to be agreed with them up front to de-risk the potential for objections. And then considering how the planning application types can be used to meet the applicant or the developers or the stakeholders or funders' needs. So again, like whether you might employ conditions or amendments later down the line if you want to just get sign off for an initial phase, or de-risk the initial application. I've used up loads of time there, so I'll pass back to Josh. But hopefully all that was useful.
No worries, thank you, Ellen. No, I mean that is the kind of meat and veg of this presentation, really, for all of you. It's those are the kind of the really most important points, and we'll go on to it. But what you can do before an application is submitted will really help you in your planning time frames. So I'll quickly zoom through this one because it's a bit of a process map just to show you how an application works once it's submitted. It then gets validated by the council. If it doesn't have the requisite information, it's sent back to the applicant, and then they can resubmit the information. If it has the requisite amount of information, it can go through the process, which is statutory consultation. So that's where it's open to the public for comments, as well as the statutory consultees, which a case officer will reach out to. A site visit can be made. Often at the point of 21 days, most councils allow you, if it's a big scheme or if there's some certain comments that need to be addressed to make it acceptable, the council will allow you to do that, to make changes to the application. It will reopen the consultation period to allow people to then comment on the changes, but it's a good iterative process for building a planning application. Once those changes and you've reached a settled scheme, a case officer will either recommend it for approval or refusal, and it will either then go through the decision-making process we talked about. Alongside that, we then go through Section 106 agreements for all things that are required legally to make the scheme acceptable. This could include things like affordable housing, open space provision, or any sort of phasing that is required to ensure that the full development comes forward. Obviously, from that point, the application is either approved or refused. If it's refused, the applicant has the right of appeal, which we'll go on to. And if it's approved, there is a 6-week period for a third party to launch a judicial review. But again, like the local plan, it can only be legally challenged on a legal basis for the process which it was taken, not for any of the planning judgments. So what happens after a planning permission is granted? Often people think that's the end of it, but it's not. So firstly, if you are refused, you have 3 routes in which you can appeal a decision. Written representations, which is where you just write to the Secretary of State via the Planning Inspectorate and say, for these reasons, we believe that the case officer erred in judgment and that planning permission should be granted. And then the council have a right of response to say why they don't think that's the case, and then a planning inspector will write a decision and decide how it is. A hearing and public inquiry are 2 more public forms of appeal. A hearing is more like a standard court case where you will be applied an inspector, and often you get KCs involved who will argue the points being made, but it will be for the inspector to decide. A public inquiry is a more open form and is used much more for strategic infrastructure projects. So things like HS2 and things like that will go through public inquiry to decide. But again, it's done through a Lord Justice, and they decide what decisions are made. So once all decisions that are approved with conditions. The first condition is always for a full application, you have 3 years to implement the consent. And for outline permissions, it is you have 5 years to submit your first reserve matters. And then the second condition is always the listed documents that form the parameters and the approved documents. So that will include the list of the plans and any technical supporting documents that are required to be followed. So you have a requirement then after that to discharge any conditions for additional details that the council may ask for. So that'll be noise impact assessments. It could be details of what material you're going to use, things like that will be attached. If you've got a scheme approved and you're building it out and you've done all the necessary steps, but you need to make changes to the planning permission, you have 2 routes in which you can make changes to that permission. Firstly, as a non-material amendment, this is the reserve of kind of very small minor changes. If it's a big scheme, it might just be changing a few details of how things are laid out. But effectively, the test for the non-material amendment is that even with these changes, the scheme would be consented without the need for any additional or change of conditions that are attached. So you can make minor changes to things like description of development. You can remove conditions that maybe apply an old standard like lifetime homes, etc., which are no longer pursued. Or you can make minor changes to a master plan. And it's for the case officer to decide whether it's a non-material amendment or not. A Section 73 is a variation of condition application. So this basically allows you to then make changes to the conditions that are attached to the permission. This can be subbing out plans so that you have different plans in. It can be changing requirements in the conditions so that they are phased. So you could say for phase 1, I need to submit a noise impact assessment before it is opened, etc. So that's how you make changes. If the changes are too big to be made via either a non-material amendment or a section 73, you will need to decide whether you need to resubmit the application with the changes, or just submit a drop-in application for the area that you are changing, as long as that doesn't make that previous permission non-implementable, which means you can't then pursue it. The final one is just if you need to amend the legal agreement that sits behind it, the section 106, the unilateral undertaking, or the section 278, which is the highways agreement, you then need to go through a deed of variation, which is a much more standard legal approach of making changes to the section 106 and re-signing the document and sealing it. I think that's everything